has graciously offered to present about essentially assumption issues that many of us face when somebody walks in the door and the person who's on the deed and the mortgage may have passed on, and what do you do next? And then, frankly, it's an issue that we are facing more and more frequently. So I really appreciate Joe offering to do this webinar, and I will turn it over to you. Thank you.
Thanks, Becky. Hi, everybody. This is Joe Sanders. As Becky said, I am with Staten Island Legal Services. I am the director of our Homeowner Defense Project. And we do a lot of foreclosure prevention here. And consequently, over the years, we have seen numerous cases involving assumptions. This is a situation where the borrower, the person on the note, has passed, or there's been a divorce, or there's been a transfer between family members, and the person, often the person living in the home, then wants to assume the loan. They want their name to be on the loan, often so that they can get a loan modification. And for anybody who's encountered this situation, it can be very difficult to negotiate a modification because you've got this added piece of assumption. So today we're just going to walk through that issue and what you can and can't do. As the title suggests, there's a federal law, Garn St. Germain, that applies here, but unfortunately for many homeowners it's not a cure-all. And so we'll look at what roles Garn does and does not play, and then we'll also go into what kind of surrounding facts and regulations and law you need to really to get an assumption done. So the first thing to note is, I just said, this is a gray area. There's no regulation out there that says, if the homeowner dies and the spouse wants to get a loan modification, the bank has to allow them to assume it. There's nothing that definitive. So this is where we come in our role as advocates. We can really help people to navigate this issue and to use the facts of their case and the law to achieve a good outcome. But the bottom line is, these are cases you're really going to have to dig into. So you're going to have to know the facts of your case, because little factual pieces are going to matter. And you're going to have to know the relevant regulation, whether it is state law, Fannie Mae regulations, Freddie Mac regulations, and obviously Garn federal regulations. So we'll go through that stuff today. Starting off with Garn St. Germain. So Garn St. Germain is a federal law, and it deals with what are called due on sale clauses. And in dealing with due on sale clauses, it touches on assumptions. Now, a due on sale clause is a clause in a mortgage that says, basically when a certain event happens, then all of the money due under the mortgage and the note is accelerated. It's due right then. Okay, it's due on the sale or the transfer, okay, involving the property. So what does Garn do? Garn St. Germain explicitly stops lenders from accelerating when the property is transferred in certain situations. And we'll go through those in detail, but in general they are, the death of a mortgagor, a transfer to an immediate family member, such as a son, daughter, spouse, even if the person is alive, the mortgagor is alive, or a transfer pursuant to a divorce or separation, which is another common situation that certainly comes up in my practice, and I'm sure other people around the state are seeing that. So what is it that Garn does not do? Okay, and this is important. So Garn specifically, it doesn't explicitly require the bank to take any action when the default is based on missed payments. Okay, So technically, a transfer to a family member, whether it's due to a death or divorce or just because you're giving property to your son or daughter, say, is a default, could be considered a default under the mortgage. The issue is that most of our clients come in when there's been a default based on missed payments. Okay, and in that situation, GARN doesn't explicitly require the lender to allow assumption. So that's sort of the starting point of what you have to understand. GARN certainly contemplates that federal law wants certain kinds of transfers to be allowed, but it doesn't really go into detail of what happens. Okay, now they've missed a payment. That's the basis for the default. It doesn't say the lender has to allow assumption in that situation. So going into GARN in more detail here. This is a listing of the specific exempt transfers, so transfers where due and sale clause cannot be invoked. The first one here is the creation of a second lien, essentially. So if you have equity in your property and you go out and you get a second mortgage, so long as there's no transfer of the actual property, then that's not considered a transfer where the lender can, sorry about this, bear with me here. Okay, that's not considered a situation where the lender can invoke a due and sale clause. You've got some random ones here, the creation of a security interest for household appliances. I've never seen that one. I doubt that that's going to come up too often. The third one here does come up. So a transfer due to operation of law under the deed. So let's say that you have husband and wife, they're joint tenants or tenants by the entirety, and one of them passes. That transfer actually happens pursuant to the deed, not pursuant to probate. So that's considered an exempt transfer. Small leases are exempt transfers. A transfer to a relative resulting from the death of a borrower. This, in my experience, is the most common. So that's the one you're most likely going to see. These are some more exempt transfers. A transfer where the spouse or the children of the borrower become an owner of the property. I have seen these where the borrower is actually alive, wants to transfer the property, transfers it to, say, a child. The child then, is making the payments but falls behind, and then, okay, yeah, the bank didn't accelerate when the transfer happened, but they're accelerating due to the default in the payment, and what do you do then? Another common one here, transfer resulting from, basically from a divorce. And then two other ones you're not going to likely see that often, involving trusts and involving the federal home loan transfers pursuant to the Federal Home Loan Bank Board. Now, there is case law involving GARN, but some of the best cases for our clients are Chapter 13 bankruptcy cases. Now, if you practice in bankruptcy, this is good news for you. But if we're talking about a state court foreclosure proceeding, which is my area of expertise, there are procedural differences that make it so they're not entirely applicable. So you're definitely going to want to, if you're briefing this issue, you're going to want to cite these cases. If you're writing an advocacy letter, you're going to want to make the bank aware of these cases, but they're not, because of the difference in venue, they're not going to be 100% on point. In Re Jordan is a very important case because it stands for the idea that an exempt transferee, right, somebody who falls under GARN, doesn't need servicer approval to assume the loan. Okay, so if it sort of takes that leap that GARN doesn't take to say that, okay, because I'm an exempt transferee, basically, I don't need to go and fill out an application to say that I'm that I have assumed the loan, and that then the bank can communicate with me, and I could apply for a loan modification, and all the rights and responsibilities that would come with being the mortgagor. Now, you'll also notice this is it's just a bankruptcy court level decision, and it's out of Florida. So again, you've also got issues using that here in New York. It's not going to be the most persuasive authority, but it stands for an important proposition. The next one that's good to know in the bankruptcy context is In re Smith. That's out of the Southern District here in New York, and in that situation, in the context of a Chapter 13, the lender was saying, look, this person's not the borrower. I don't have to consider them for a loan modification. The court essentially said, yes, you do. The transfer was exempt under GARN. For you to come in here and say that they can't be considered sort of ignores that, ignores the intent of GARN. So that's another good decision. But again, especially in Smith, it really applies in a Chapter 13 context where the court has a lot more power to manipulate and maneuver debt because of their bankruptcy jurisdiction. So important cases, but not going to solve the problem just on their own. Now, moving on from GARN and case law about GARN, another important piece of authority that we're going to want to be able to cite and to talk to, to speak authoritatively about when you're dealing with lenders on assumption issues is the mortgage itself. So, just as a general contract law concept in New York, absent explicit language in the contract to the contrary, a contract is assumable. So that also would apply to a mortgage contract. Now, is there explicit language to the contrary? That's the question. In my opinion, most pre-2008 Freddie, Fannie form mortgages don't contain explicit language preventing assumption where GARN applies. So in a situation where there's an exempt transfer. So again, if this is me transferring, the loan to my neighbor who I'm not related to, transferring the property to them, it's not going to be an exempt transfer under GARN. And so there is explicit language in the mortgage that would stop the loan from being assumable. But as I'll go into in more detail here, if it's an exempt transfer under GARN, the mortgage doesn't have language that would prevent the assumption. Okay. And I'm generalizing here. As we all know, a lot of mortgages are form mortgages, but there's going to be differences mortgage to mortgage. So you're going to need to know the language of your particular mortgage. So there's two sections in a general form mortgage that are going to apply. The first one is Section 18. Now, this is the section that contains the due on sale clause. It says, when there's a transfer of the property, the lender can call all the money due under the mortgage loan due right then. Now, GARN obviously bars application of Section 18 for exempt transfers, and Section 18 explicitly acknowledges here that the due on sale clause shall not be enforced. Let's see if I can. Shall not be enforced by the lender if such exercise is prohibited by applicable law. Now, that's a direct reference to GARN, and so the mortgage does not specifically bar assumption in that situation. Now, Section 13 of most form mortgages allows the lender to approve an assumption in writing, essentially requiring the homeowner to apply to assume. And this is a situation that many of us see if we're trying to negotiate a loan modification say, in a settlement conference context, you say, okay, I'm going to apply for a loan modification. You'll often see the servicer come back and say, well, first you have to apply to assume the loan. It'll be like it's often a separate application. So Section 13, the mortgage is going to apply in this type of situation. However, Section 13 explicitly says that it's subject to the provisions of Section 18. All right. So, what I've argued in cases where I've dealt with this is that means that the language from Section 18 that the due on sale clause shall not be enforced by the lender if it's prohibited by applicable law also applies to Section 13. So, again, this is a gray area, but there's certainly an explicit argument to be made that the mortgage itself does not explicitly bar assumption where GARN applies, and doesn't even require an application for assumption. Now, given your case, as a practical matter, you may want to go ahead and do that application, particularly where you're in a settlement conference and everybody has a duty to negotiate in good faith. But you can certainly make the argument that this thing is assumed when the party assuming, your client, takes any kind of action that shows that they are going to take on the rights and responsibilities of the loan. Generally speaking, that's going to be making a payment. You could argue that applying for a modification would constitute an action that would assume the loan. Even any kind of communication to the lender, just saying, hey, my spouse passed. I live in the home. I want to take over making the payments on this. If you were advising the client to communicate with the lender, you could even use the word assume, right? I'm assuming this loan, and arguably the mortgage would not bar that. Okay, and as Becky said, feel free if anyone has questions, feel free to jump in as we go along, because I know we're covering a good amount of territory here.
So far, we don't have any yet.
Okay. All right. Another area of regulation that you're going to want to know is regulation that would apply to Fannie Mae and Freddie Mac. As we all know, Fannie and Freddie control a good portion, probably over half of the mortgage market in terms of, owning or backing or having securitized mortgages. And so their regulations apply in a lot of cases. So you're going to want to use your Fannie Mae, your Freddie Mac loan lookups online, find out if your homeowner's loan is a Freddie or Fannie loan, and then go to the Freddie and Fannie regulations, because these are going to provide some of the most explicit authority on assumptions that you're going to find. Okay, we've seen that GARN has gray areas. We've seen that the mortgage certainly touches on it, but kind of harkens back to GARN and isn't the clearest. Fannie and Freddie are going to provide some of the most clear authority on what to do in these situations. So Fannie Mae, as a general matter, prohibits servicers from requiring an application to assume a mortgage where there's an exempt transferee. Okay, that's from their servicing guide. You can see here we've got the link to the most recent full PDF of the servicing guide. That's their general rule, and that sounds great, right? Like, okay, you can't even, if it's a Fannie loan, they can't even ask me to apply. I just can assume it, right? However, there's an extremely large exception that's going to apply to a lot of our cases. So in any case where we want the transferor not to be liable for the debt, okay, then Fannie is going to require an application. All right, so I think that it's the servicer is certainly going to argue that where the transferor has passed, right, is no longer alive, that's going to constitute a release of liability, and they're going to require or try to require an application. In a divorce situation, right, you're going to be hard-pressed to probably to find a situation where, one spouse is going to be giving the home to another pursuant to a stipulation of divorce, and they don't want to be released from liability. I guess you could try to negotiate through that through the divorce, but it doesn't seem like something that's going to be in the interest of the party that's not going to have not going to own the property anymore. Now, so if you want anybody to be released from liability, not only do you have to apply and have their creditworthiness reviewed, but if the mortgage is insured, okay, the mortgage insurer must also sign off on the assumption. And as a practical matter, that's something that's going to be a large hoop to jump through because you're bringing in this third party, and they've got to look at stuff, and people are going to have to, there's going to have to be behind the scenes, transfer of documents from servicer to mortgage insurer, and would be a real pain, and could even be the source, whether the servicer tells you or not, of some of their document requests. Like, why did you ask me for this document 6 times? Well, it might be that the mortgage insurer has asked them for the document, and adding one more link to that chain just exacerbates the problems that we all see in trying to negotiate loan modifications. So for our purposes here, the exception really eats the rule. So, so far, based on what we're, based on the Fannie regs we've gone over so far, an application is going to have to happen, and that's going to take time and potentially be a bar to your client getting an assumption and a subsequent modification. Now, there was just a Fannie Mae servicing announcement last week, I think, Wednesday, that dealt with assumptions and that provides some much needed clarity, further clarity on this issue. So we've got a link here to the new announcement, and I encourage everybody to take a look. This new Fannie regulation requires servicers to reach out to the new property owner for exempt transfers. So this is actually telling them to go out before a default based on missed payments, which is key, to reach out to the new owner, to ask them to keep making payments, to ask them to apply for the assumption, and a loan modification. They term it, foreclosure prevention alternative here, but that's generally going to be a loan modification. If they can't bring the loan current, the new regulation says that's not going to be a bar. Now, one of the situations, and we'll talk about this in more detail later, but one of the situations that I've certainly been in and that I know others have seen is where the servicer will kind of get your client in a catch-22 where they say, okay, like before we can consider you for an assumption, you have to bring the loan current, right? But you have to assume the loan before you can be considered for a loan modification, which would be the way that, many of our clients are going to bring the loan current. So you're stuck, they've got you one way or the other, right? You need an assumption to get a modification, but you need a modification to get an assumption. This provides clarity and says if they can't bring it current, they still have to be evaluated for workout options. So this is really a big step forward, and is something that we are going to need to use on a regular basis where there's a Fannie loan. Now, this next point here makes it a little more complicated. So if the servicer says, okay, yeah, you know what, your spouse passed, you're an exempt transfer, we've looked at your loan modification package, we think that a workout option is appropriate, it's got to actually submit the case to Fannie, okay? So again, this, that extra step, that bringing in of another party, Fannie in this case, has the potential to create administrative and practical barriers, right? The single point of contact is sick, or their fax machine didn't work right, or whatever. The same stuff that we see, trying to get loan modifications in any context. There's the potential for those kind of practical problems to come in here, where you've got to submit it to Fannie for consideration. So this is an encouraging clarification. Certainly the step that says, this right here is the most important part. Even if they can't bring it current, they have to be evaluated for workout options, including the streamline modification, that new modification that came out in July. So that's encouraging, but this just came out on August 28th. We haven't had any opportunity to see, how this is going to play out, and until we see some actual results coming from this, this is not a magic bullet, essentially, and you're going to still need to do the same kind of, hard-nosed, detail-oriented advocacy that you would have had to do before this regulation, after, until we see some kind of a practical change to suggest otherwise. Okay, so that's Fannie. The other big player in the the government-sponsored entities, obviously, is Freddie Mac. Now, as a general matter, the starting point for Freddie is that the language in the mortgage controls, except where prohibited by federal law. So it's sort of like just reiterating GARN. Okay, in the event that the mortgage doesn't mention GARN, like GARN applies, and you can't accelerate a due on sale clause for an exempt transfer. Now, with both Freddie and Fannie, you've got to be careful when you're looking at the regs, because this regulation here that I've cited technically applies only to performing mortgages. But it's also referenced in the section for non-performing mortgages, so you could argue that it applies more broadly. Now, for those not familiar, I thought I'd quickly look at the all regs system, because it's a little bit, it's not necessarily intuitive, and it's where you're going to go to get your Freddie Mac regulations. You can also get Fannie Mae on all regs. And it's good in the sense, although it's a little difficult to navigate, it's good in the sense that it keeps you up to date all the time, because it's an online tool. So you go to the Freddie Mac seller and servicer guides, the single family, right? You can go here to access the guide, and you're going to want to click on all regs. This is going to bring up another window. And you've got now, you've got here all of the Freddie Mac regulations that pertain to single-family homes right at your fingertips. So the one that we're going to want to look at, let's take a look here. Let's get a good one. Okay, so let's take a look at this one here. So where a mortgage is non-performing, okay, and I'll show you the distinction within the all regs, is the performing and non-performing sections. Freddie Mac requires servicers to consider a simultaneous assumption and a Freddie Mac standard modification where there's been an exempt transfer. Okay, so again, this is similar to the new Fannie Mae reg that we just looked at, in that it's going to require them to look at a modification. They can't just say, oh, you know what, you got to bring it current before you can assume, and we're not going to let you bring it current until you assume it, right? This is a regulation you can point to get out of that catch-22, all right? So, all right, now going back to, all right, here's our guide.
Joe, there's one question I have here. Please address. So the question is, what if there is no mortgage insurance?
Well, I mean, that's going to be a good thing as a general matter for your client, because in the situation of Fannie Mae, right, you're not going to have to go, the servicer is not going to have to go to the insurer to get their sign-off on the assumption application. So as a general matter, that's going to be a good thing. Okay, so looking here, we go into the Single-Family Seller Servicer Guide, Volume 2. Okay, and this is the section now. You've got the distinction here, right? Volume 2, Chapters 58 to 63 are servicing performing mortgages, and Chapters 64 to A69 are servicing non-performing mortgages. All right, so you're always going to want to know what section you're in, because a lot of times, different rules are going to apply to loans that are in default versus loans where the person is making all the payments. So let's see, let's get that exact site here. So this is B65.28, when to consider a mortgage workout assumption. All right, so, oops. Okay. All right, so you're going to go to D65. Okay, let me see. D64. B65.28. Okay. Okay. So here it is. This is the applicable section. Now, obviously, you're going to want to. This is going to refer you back to other sections. This is what we're interested here: simultaneous assumptions and modifications. And the servicer must, consider assumptions of mortgage in situations where the borrower is deceased, yada yada, except exempt transfers, essentially. So, as with all Freddie Mac loans, being conversant and using all regs is going to be key, because it's going to allow you to go in, get the nitty-gritty regulation, and find some, potentially positive tools to use to get your servicer to at least look at an assumption where, as many of us know, they can be reticent to do so. So, okay. All right. Now we've looked at regulations.
Joe.
Go ahead.
Sorry,
yeah.
Before we move on, but we seem to have a number of questions now. I thought maybe now is a good time to stop or pause.
Yeah, sure. We can take some questions now.
Okay, so let's see. Why is a release of liability needed when there is an assumption, and doesn't the assumption release from liability the person the mortgage is being assumed from?
Right. So, as a general matter, right, you're not going to, let's say that you're applying for a loan modification, right, and your client makes $5,000 a month, right? You're going to want, in order to get let's just say you're applying for HAMP, okay? Now, in order to get the most affordable payment for your client, you're going to want them to just look at your client's income, right? Just that $5,000, because you're going to take 31% of that amount to get to the payment. Now, if you've got, let's say it's a divorce, right, and you've got this other spouse, and they also make $5,000 a month. But because there's a divorce, they're not speaking to one another, right? And the other party, right, the party to the marriage that's not your client, is probably not going to want their income considered for the modification, right? They're going to want a release from liability under the note. So that's why that release from liability section is so key. If you had a situation where, for whatever reason, your client wanted to assume the loan and the other person was okay, the current mortgagor was okay with their, income being considered and continuing to maintain liability under the note, you could argue with Fannie that, hey, this is not even, you can't even require me to apply, but because you're generally not going to want that income to be considered, you know, that's why that issue is very important.
And the next
Were there other questions, Becky?
Yep. So what happens if a mortgage company is paying the insurance? Do they get 2 bites at the apple?
So it sounds like, and I may be wrong here, but it sounds like we should make a distinction between homeowners insurance and mortgage insurance. The insurance that's contemplated by the Fannie Mae regulation is basically insurance for Fannie, right? Fannie goes out and gets insurance from an insurer, and if the homeowner defaults, then Fannie's still going to get paid. So that's the situation where that's the type of insurance that we're talking about. We're not talking about homeowners insurance. So, but where Fannie does have insurance, you know, that regulation implies that you're going to, or I think it's pretty explicit, that you're going to have sign-off from both, I believe from Fannie and from this insurer. So it just adds another party that makes somebody else to object and say no.
I.e. more of a chance to stop it from going through.
Exactly, right. It would technically. I mean, if you know, it's just more chance that the modification is not going to go through if that insurer doesn't want to see any kind of change.
Questions for now. Is a new note recorded if assumption is approved?
You know, that's a good question. I could certainly see a lender or servicer wanting a new note. I've not seen it. I've seen a note extinguished where we had a case where it got very contentious and they actually just they got rid of the note altogether and just had the mortgage on the property, so eliminated personal liability. I think from a lender's standpoint, that's one of the reasons why they're kind of reticent to do these things, because, you know, they might want a new document, but then it's like underwriting a new loan, and so from the lender's perspective, it creates, right, that issue that you bring up creates a lot of these problems. So, you know, if they wanted my client in one of these cases to sign a new note, so long as I advise the client about, you know, personal liability, and which is something you're going to have to do anyway, right, when they're assuming the obligations of the loan, you know, if it got the job done, I would certainly be open to that.
So last for now. Oh,
yep.
Sorry, go ahead.
No, go ahead.
So the last question for now, it looks like you might be covering some of this more coming up, but what legal recourses does a deed owner have in a foreclosure action when he or she is not on the mortgage?
Right. That's a good question. You know, they certainly have a lot of the same defenses and potentially counterclaims that somebody who is on the mortgage would have. But if you're talking about a loan modification, right, then they're going to be in the same situation that we're talking about here, where they're not on the note, and so you're going to applying for a modification, if that's what they want, is going to be difficult. The first thing you're going to want to look at is, how did they get on the deed? Did it happen before or after the origination of the mortgage? Would that be considered an exempt transfer under GARN? And if it would, right, then you could kind of go through the steps that we're going through here. If they're not related, if GARN doesn't apply, I think that makes it a tougher nut to crack. Okay, I'm going to move on now in the interest of time. We've gone through regulations. We've gone through the language in the mortgage. Let's talk about some practical steps, you know, outside of all of this sort of esoteric, what should be done, you know, how do you actually make that happen? So in the case of a deceased homeowner, the most important thing you can advise your client to do is get into probate court and be declared the executor of the estate. In a situation where the bank is refusing to speak to the person, to your client, because they're not on the note, this gives them legal standing to at least talk to the bank. Now, you know, one of the first cases that I dealt with this issue on, we were able to go into settlement conference. You know, our client had been declared the executor. They had the order from the probate court. We submitted that to the bank. We were able to successfully argue that because they were the executor, they had to be considered for a modification in just the same fashion that the deceased party would have been, and the bank did do a modification in that situation, acknowledging them as the borrower. We've got some case law here. It's out of the third department. For those of you in the third department, it's a great case. For those of us in first and second, it's good, but it's not directly on point. But to the extent that you're briefing this, this Cornaby case, stands for the proposition that the bank has to deal with the representative of the estate. And the bank should have named the estate as the party to the foreclosure action, where there is a foreclosure action. If the bank names the borrower as opposed to the estate, as a side issue, you could potentially move to dismiss the case.
Hello? Joe?
Apparently we may have lost Joe, so give us just a second here.
Michelle, I'm going to try to give him a quick call.
Okay. Bear with us, folks. It appears that we've lost that we've had an audio issue with Joe, and we'll try to get him back on the line momentarily.
Okay, hello?
Hi, Joe. Welcome back.
Hey, so I don't know what happened. I could hear you guys, but I guess it cut out for some reason.
Okay, well, you're back, so we'll just keep moving forward.
Okay, all right. So let me go back. I don't know if people have got the last slide, but basically, where there's been a deceased party, you want your client to go to probate court, you want them to be declared the executor if possible, and you want them to do that ASAP. Once they've been declared the executor, if the bank is saying they won't talk to them because they're not the borrower, then the bank no longer has an excuse. And we've got a third department case here that stands for the proposition that the bank would have to do that. Okay. Practical steps for divorce or separation. You're going to want to get the stipulation of divorce that gives your client the home. And if possible, if you're still negotiating that, or if you know the attorney who's negotiating that, you could put in language that would explicitly allow your client to assume the loan, right? That the current borrower consents to your client assuming the loan. And this is going to be an exempt transfer under GARN and proof to the bank that this divorce actually happened. Okay, moving on. Practical steps, right? outside of litigation, say, before a foreclosure has been filed, or for any housing counselors out there, you could even communicate directly with the bank in this manner. You're going to want to write an advocacy letter. You're going to cite Garn St. Germain. You're going to cite the mortgage. You're going to cite the Fannie Freddie regulations that might apply, and argue that the bank can't stop your client from assuming the loan. Go through the stuff that we just went through. This is an exempt transfer under Garn. Cite any relevant Fannie Freddie stuff. The mortgage doesn't allow you to block my client from assuming. So, they've assumed the loan, now consider me for modification. You're going to want to look at making this letter a qualified written request. Okay? All that means is that you cite a specific statute under RESPA, and I've got the cite here. You identify the name and the account number of the borrower, and it needs to be sent to the proper QWR address. What making a letter like this a QWR does is that it requires the servicer to respond, and respond in a timely manner. So it's within 30 days, or if they ask for more time, within 45 days. So again, this is a practical step to put all that regulation that you've got in front of the servicer and make them give you some kind of an answer. Okay. The other procedural vehicle that you can use to get this stuff in front of the servicer and kind of try and force their hand is through settlement conferences. And, one vehicle that, my office has been successful in using is pursuing a motion for a lack of good faith negotiations and conferences, which is required under CPLR 3408. So, as a general matter, where, a foreclosure plaintiff fails to negotiate in good faith, the court may bar the collection of interest, fees, and costs. So this is a powerful remedy to the extent that you can you could get a court to make a ruling that there's been a lack of good faith. Let's talk about what might constitute a lack of good faith. One common thing that I've seen, I know others have seen, is this catch-22 that I mentioned earlier, where a servicer will refuse to recognize the assumption in the loan until it's modified or brought current, but they also refuse to modify or bring it current until they approve the assumption. So, a case where I briefed this issue, they had done this for, I think it was almost 2 years, where they came back and said, oh, we can't allow you to assume until you modify, and then they'd come back when you apply to modify, and they say, oh, well, we can't do that until you assume. So, there's a good case to be made that this is a lack of good conduct. The court can really, that's a really powerful example where you can see how the circular logic is really causing your client prejudice. Now, one issue that you're going to have to, deal with here is how is it that your particular court makes the determination there's been a lack of good faith. Some, like in Kings County, are actually going to require a hearing where they're going to take testimony, witnesses, introduce exhibits. Some, like here in Richmond, are going to require an application on motion. And, in Richmond County, when CPLR 3408 was first instituted, we could even make oral applications for interest tolling and other relief for a lack of good faith. Some counties may still have that. The bottom line is that no matter how you get that in front of the court, you're going to need to document the bank's failure to negotiate. So you're going to need to save denial letters. You're going to need to save correspondence with your client pertaining to additional document requests. You're going to need to keep a record of a contemporaneous record of what happens at conferences, because you're going to need to be able to show the court through evidence that there's been a lack of good faith. Now, I want to go back, if we have more time at the end, to talk about a couple more recent cases on the lack of good faith, because I think that settlement conferences is a venue that many of us are going to be dealing with this. But I want to talk quickly about the ideal of equitable estoppel and some questions to ask your client to get at that issue. So, has the bank ever negotiated with your client in the past? As we know, many of our clients, when they first come to us, they've already been dealing with the bank for an extended period of time, right? They may have even had past modifications, past foreclosure actions. To the extent that you can find a situation where the bank, right, say there's been a homeowner, the mortgagor passed, the spouse took over, the spouse continued living in the home, continued making the payments, then fell behind. And after falling behind, at some point the bank acknowledged that she was the one paying the mortgage and dealt with her on any kind of level, you can make the argument that they're stopped from saying that your client can't now assume the loan because they've already let it happen. Okay? There's a very good recent Second Department decision on this issue that applies to real property, not foreclosure specifically, but to the idea that where a property owner has the opportunity to object and doesn't, they can't come back and change their position in the future. So you're really going to want to probe your client about, have you dealt with the bank in the past? Have they acknowledged that your spouse passed away in the past? Have they talked to you on the phone in the past? Have you even done a modification with them in the past? And a lot of times these are issues that your client may not want to talk about. They're touchy issues. They feel embarrassed, like so many issues surrounding debt and foreclosure. So you're really going to need to probe. You're really going to need to encourage them to bring in all related documents. You might want to do some research at your local county clerk to see if there have been past foreclosures. Because if you can get that kind of fact-based information, it can be a big help in using this equitable stockpile argument. Okay. Now, briefly, let's see. I talked about, I cited, a case in there, McKenna, for, a lack of, or failure to negotiate in good faith. But there are two really good recent cases out of the Bronx. U.S. Bank versus Shinaba, and the other one is U.S. Bank versus Rodriguez. Now, these were both issued by Judge Torres in the Bronx. I think they were middle of last month that they came out, and unfortunately I don't have cites yet, which is why I didn't include them. But I'll send them to Michelle, and she can distribute them. But both of these cases could be applied to an assumption. They don't deal with assumption directly, but they deal with extensive delay on the part of the servicer. In the Shinaba case, which was shout out to Oda Friedheim, who did that case for legal aid. There was something like the court cited 17 settlement conferences. Over 2 years. These are facts that are going to apply to an assumption situation, so you can use that delay. Another good piece that you could use out of Shinaba is where the court noted that the bank failed to appear at conferences with counsel fully authorized to dispose of the case. It's rare that you get counsel with any kind of authority, let alone authority to allow an assumption. So that's a good fact there. In the Rodriguez case, that was James out of LSNYC Bronx. Again, stuff that you could use in an assumption situation. You have bank failure to comply with the referee's directives, right? Probably not going to be that hard to get a referee to say you should consider them for the assumption. Failure to evaluate for HAMP occurred in U.S. Bank versus Rodriguez. You could apply that in your case to say, like say in the instance of Fannie Mae with that new regulation that just came out, you could say, well, they failed to consider them for a modification despite the fact that an assumption was required. They violated the Fannie Mae regulation by doing that. So two cases that, yeah.
Sorry, go ahead. We have several questions lined up here. So
let's do the questions. I'm ready.
So can you spell the last names of the defendants and mention the plaintiffs again in these two recent cases you're talking about?
Yeah. So you can see I've got the caption for Rodriguez up here on my screen, and I'll get the caption for Shinaba here. So, like I said, I tried to get to see if I could find sites for these, but they're recent enough that I wasn't able to. So, the Shinaba case is U.S. Bank against, I'm going to mispronounce the name here, Jumok Shinaba, and the other one is U.S. Bank versus Jorge Luis Rodriguez.
And then we've got several more questions. What if the client does not have the funds to go to probate court to be declared executor of the estate by the court, or they never get around to being declared executor? What can the client do, and what will the bank do?
Well, the first thing, as a practical matter, even if, we've had clients come in here where they haven't been declared the executor yet. We've told them, here's some referrals, like very general stuff to the County Bar Association. They can tell you people who deal with estate law, and then you can go get this done. And we've had that happen, within a relatively short time frame, or at least a situation where they could show the court hearing the foreclosure that they were taking steps to do that, and eventually become, be declared the executor. In a situation where they lack the funds, I mean, obviously that's for our clients, this is not like an easy ask. It's not an easy ask for anybody, right? Go out, find the state attorney, go into court, be declared the executor. There's no easy way around that. I don't know of anybody who does that pro bono, but it's a situation where if they have income enough for a loan modification, there should be attorneys out there who will do this for a fee that would fall within, a monthly payment or two of a mortgage. And so, well, it's not an easy task for a client. It's one that you need to emphasize the importance of, because if they really want to keep the house, that's a practical step that they can take that will greatly increase their chances.
I would say on some local levels, at least in Monroe County, our probate court is very consumer-friendly, I guess you could say. So the gentleman who is in that office, they are very sympathetic, and they're very helpful to folks walking in the door trying to figure their way out and figure their way around. So I would agree. I think there's very few pro bono attorneys who are able and willing to do something like this for free. There are some, I believe, but it's difficult to find them. But it is possible for perhaps some of your more sophisticated clients to be able to do it on their own.
Yeah, I would agree with that. I think we've had a client or two here who have done it on their own.
Okay, so the next question is, what if it's a small estate that's been closed and the bank is only suing the deed holder, the daughter, and not the estate?
Well, I think that they would have to sue the estate. I'm not 100% sure on that. Speculating a little bit, but the RPAPL 1301 or 1311, something like that, requires all parties with an interest in the property to be named defendants. And even if the estate is closed, just by the fact that the debt was in the name of the deceased, I think you could make the argument that they would have to be named regardless of the status of the estate. So if that case came to me, that's a situation where if the bank is refusing to talk to the executor of the estate, and we're even to say, oh, well, you're not a party, that's a situation where I'd look at potential dismissal, because although it would be easy enough for them to amend, I think if they were showing reticence to do that, maybe that's how you get your leverage. Maybe that's the sort of the extra piece that you add on besides GARN that gets you to an assumption, right? Because that's really what we're talking about is adding adding some kind of authority or procedural leverage to Garn St. Germain to get your exempt transferee over the hump and into an assumption and modification.
One more in the similar vein. If the spouse is declared the executor but not on the loan, does it complicate things when there are possible heirs? And do all the heirs have to sign off their interest from the bank's perspective? Hello? I think we lost him again. Well, it looks like we had a couple of leftover questions. What I'll try to do is ask Joe to address some of these. Oh,
I think he's trying to call. He's trying to call in again.
I see that. Now, if folks are willing to stay a bit past 1 o'clock here, maybe Joe can answer a few more of these questions.
Okay, can you guys hear me?
Yep.
Okay, sorry. I think it's something to do if somebody calls me. I think it might block me out. Anyway, sorry. Should I continue with the last question?
Yeah, let me ask. I don't think we heard any of your answers. So if the spouse is the executor but not on the loan, does it complicate things when there are possible heirs? Do all heirs have to sign off their interest from the bank's perspective?
Yeah, that's a great question, and it really does complicate things. You know, as a general matter, you know, I think you would have to have agreement from all parties, you know, all heirs, all parties with an interest about who was going to live in the house, who the house was going to go to from ownership of the property standpoint, and then, you know, who was going to take over responsibility for the loan. So in a situation where you had, say, competing siblings arguing over who was going to get the house, I think that's got to be resolved before you can come to the bank and say, well, you know, I'm the party that wants to assume the loan, and you know, the property's been transferred to me, and I think that's got to be resolved before you even get to any of this. So, great question.
Okay, if the investor is a non-GSE, would an advocate just go by the Garn St. Germain guidelines?
Another great question. I think that I'm not 100% conversant in this because the loans that I've dealt with on this issue have been Freddie or Fannie. I believe that the latest copy of the HAMP handbook has some authority on this, and I've pulled up a relevant section here. Let's see. So it says they have to send them requirements for how to assume it. And, you know, they may, if it happens during a TPP, they can, you know, it basically gives the servicer a lot of leeway. But, so there's nothing really definitive in my experience. Again, I'll say that with the caveat that, you know, my experience has mostly been GSE loans on this issue. But to my knowledge, there's nothing definitive that's going to be a positive for the homeowner in the non-GSE context. And if you guys want that that site there, This is the HAM Handbook 4.2, Section 8.9.2, remaining non-borrower occupants. Other questions?
There were, but it's a bit, you might want to read it first. He's asking for a very specific, I don't think so. No, I think we're good right now.
Okay, all right. Okay, I think that's, those are the basic outlines. It's something, assumptions are something that you can get done, but you've got to really, use all the regulation and facts at your disposal to push servicers, because it's traditionally not an easy hurdle to get over. So, thanks for everybody who participated, and I'll send Michelle those two decisions that we discussed at the end as well.
Yes, and I'll forward those off to everyone who participated today. And finally, for those of you who have been waiting for the CLE code, I did put it in the chat function on the control panel, but I'll verbalize it here. It's A1F3W. That's A1F3W.
All right. Great. Thank you so much, Joe. Thanks, everyone.
No problem. Thank you.
Bye.